Good morning, everybody. How's everyone doing today? Good. Well, today I have the special privilege to moderate the escrow panel, and we have three of our finest escrow officers here. So without further ado, let me go ahead and introduce you to them. To my immediate right is Jacqueline Chow. Jacqueline, she is the owner of Champion Escrow. She's 26 years in the escrow business, a certified senior escrow officer. She's currently serving on the executive board of the Escrow Institute of California. She's also the past director for the Escrow Associates of San Gabriel Valley, past director for CARPA, and she and her husband, Bob, were the 2014 West San Gabriel Valley Association of Realtors Affiliate of the Year. So that's Jacqueline. In a minute. And then to her right is Alina Chu. Alina, she's an escrow officer and notary public. She's at Glen Oaks Escrow, over 35 years in the escrow business, and one of the owners of Golden Escrow for over 20 years and sold in 2015. And then to our far right, we have Vanessa James. She's the escrow officer and mobile notary public. She's at Viva Escrow, 18 years in the escrow industry, the 2016 and 2019 president of the Escrow Associates of San Gabriel Valley. She's the director with California Escrow Association, and she's also the 2012 West San Gabriel Valley Association of Realtors Affiliate of the Year. That's Vanessa James. So for the next 15 minutes, we're going to do some questions that are commonly addressed, or some of the special cases that our escrow officers have handled. So I'm going to go ahead. I'll start with Jacqueline. Jacqueline, I'm curious, can we use Bitcoin to purchase a property?
Bitcoins. Is everyone familiar with what Bitcoin is? Okay. Well, in a nutshell, Bitcoin is a form of virtual currency. And it's important for us to know that existing laws and financial codes do not allow licensed escrow companies to receive the virtual currencies. All funds that go through escrow must be in US dollars. So if you have a buyer who has Bitcoins or any other of crypto currencies and want to use them to buy properties, they must first convert it into US currency, then send a wire to the escrow for closing. And they can use brokers like BitPay to do the conversion for them.
Interesting. I never knew that. Thank you, Jacqueline. And Alina, let me ask you, how do you manage your time while traveling and closing escrow simultaneously? How do you balance all that?
Well, believe it or not, we live in this area, and this happens to us really common. It happens all the time that finally you have a transaction put together, and then your principals will be leaving on vacation. It happens, or you'll be leaving for vacation. We're lucky that we're in this day and age that we have technology to help us. So nowadays we have the ability to do DocuSign, but the only thing is when you're traveling abroad, you have to be sure that they have adequate internet access, because a lot of times you go to remote areas and there is not much of a remote access. Now there are certain cases that the DocuSign is not acceptable. So you do it does require a wet signature. So you do have to be sure to plan ahead. And by planning ahead, what you could do is, you can sign a power of attorney. So by a power of attorney, especially for if you're using a power of attorney to sign loan documents, the lender needs to be aware, so they have to be approved as well. So you have to make sure that we make arrangements to also notify the lender to get that power of attorney approved. Now, as far as notary is concerned, if you need to do a notary and you're signing outside of the U.S., it has to be signed in front of the U.S. consulate. It has to be sign at the American consulate. So, and sometimes when you make appointments to sign at the American consulate, it may take you 2 to 3 weeks to get an appointment. So you have to bear in mind that, be sure you ask your customer if they are traveling while you are in escrow. But everything, it is doable, and we can help work around that. Thank you.
Thank you, Alina. Vanessa, with all the talk of wire fraud, what does a realtor need to be aware of?
There are a lot of fraudsters out there. You have to really, really absorb that, take that in. Don't think that you won't be a victim. They're out there, they're preying on realtors right now. There is certain steps that you can take to so that you're not a victim of wire fraud. And those things, if you're not sure, you can always refer back to your CAR form, WFA. If you got a flyer from me, I have some tips on here. Little type, I put WPA, but it's WFA. You'll want, from the beginning, to get your escrow officer's contact information and give that to your clients. Give it to them verbally. Have them write it down, give it to them. And have them contact the escrow officer before they wire their funds. For the buyers, have them contact. We give out wire instructions, and on here we have our contact information. But fraudsters, they're just waiting. They're waiting. They see your listing. They see when you get the listing. They see when it goes into escrow, and they're just waiting for certain, things to happen, like an email that says wire instructions in the subject line. You never want to do that. Give your client the contact information for the escrow and have them confirm those instructions with them directly. And then take yourself out of the equation too. Have the escrow officer email the wire instructions directly to your client, because that'll eliminate your liability. Most of the escrow companies have either secure or encrypted email. When we send out the instructions, they're protected, but if we send them to the realtor and the realtor forwards them to their client, do you have that security? You would be the weakest link if that were the case. If you forward it on and then it got hacked, then you're liable, not the escrow. Avoid sending non-public personal information via email or text. You never want to send your client's personal information that way, especially when you're in Starbucks. Again, they're preying on you. They know we do business at Starbucks. You have an open Wi-Fi. All the information's there. Avoid putting that in. Use secure systems. And then when you have a seller at the end of the transaction, we're going to be wiring funds to them, right? So usually the escrow company will confirm. Have your clients be alert and aware that the escrow is going to be sending money. Have them confirm and not change the instructions at the end. There was a case recently that we heard coming from Orange County, an escrow officer in Orange County. She was closing up escrow end of the month, last day of the month. And she got last minute requests that instead of a check being cut, they wanted a wire to be sent. So she's like, okay, well, you need to fill out these instructions. You know, it's last minute, have it notarized. They send it in, it was notarized. And then the agent walks into the office to come pick up the closing package. And she's like, wait, I just got an email from you. He's like, I didn't send an email. And he's like, yeah, I just got wire instructions. And he's like, no, and while the realtor was there in the escrow company's office, they got 3 more emails from the supposed realtor asking about the wire and do this and do that. And luckily the escrow was able to stop it and not send the money to the fraudster. So just really, really be aware, hyper aware to it all. It's so much out there. I know we keep hearing about it, but it's like not one escrow meeting do we ever go to that we meet that we don't hear of a case of something like this happening. Like every week I hear something. So, and usually it's coming from the realtor, unfortunately. So be safe, be aware.
Thank you, Vanessa. Jacqueline, escrow asked for a complete copy of my client's trust agreement, but my client is not comfortable providing their private information to anyone. What can I do?
Okay, well, escrows ask for a copy of the trust agreement because we need to know the existence of the trust and that the person that's acting on behalf of the trust has the authority to do so, whether they are buying or selling a property or just getting a loan. Now, if the customer is not comfortable at providing their entire trust agreement, they may just provide those pages that contain the trust, the name of the trust, the persons who created the trust, the trustees of the trust, and the powers that these trustees have, and the signature page. Or if they have in their file a certification of trust, they may also provide that. As long as that certification of trust is in compliance with the California Probate Code 18100.5, they should be able to use it. Now, once escrow gets the trust documents, we also send it to the title company for review. If after they review and they see that it's still insufficient, they may still require the entire trust agreement. Okay.
Thank you, Jacqueline. Alina, what is the pre-sale self-certification program for the city of Pasadena?
Okay, this is brand spanking new. Okay, this is the city of Pasadena. They were very excited to announce beginning this month, April 1st, just effective this month, that they launched the pre-sale self-certification program. Now, a little background on this program, the original occupancy inspection program was adopted back in the 70s. And of course, they adopted that to be sure that the properties, the residential properties are addressing the major life and safety code violations. So they want to be sure that everything is up in par. So this new self-certification program, they do have some requirements. Now, they must not have any open code compliant cases to qualify for this certification of completion. Now, the property, the actual square footage cannot exceed the current LA County Assessor's record by more than 10%. The property meets the fire prevention, detection, and exiting requirements. And the property does not have any unpermitted new constructions, additions, conversions, or accessory structures greater than 120 feet. So if you meet these guidelines, then the seller can apply for this self-certification, and you can apply it by either online at an additional cost, or the seller can also always apply in person. Now the cost is much lower, and it's also much faster. So they are processing at a much faster pace. Now the other thing that it also covers, the other part of it, is there is a sidewalk assessment fee. Because now that this certification can be done online, then they're giving the option to the homeowner to see if they want to pay for this sidewalk assessment through the escrow. So they will give us a certification, and it will stipulate on there whether the sidewalk assessment is due or not. Now, the sidewalk assessment is, the city, they do conduct periodic review of the property to see if the sidewalk is up to par. They do put this, for you to fix the sidewalk, it is the owner's responsibility to fix that. So they do check it out from time to time to see if this is up to par. If not, they do bill the homeowner. So this is part of the self-certification program. They will include whether we need to pay this fee or not.
Thank you, Alina. Vanessa, when does a pre-sale city inspection report need to be ordered, and who is responsible for it? And can't the clients just wait it?
Anyone know that, when it's supposed to be ordered? It's a pre-inspection report. So those pre-sale inspection reports, so it really should be done before the property goes into escrow. Okay, so like Los Angeles, Lena was talking about the city of Pasadena. For the city of Los Angeles, there's quite a bit that goes into it. So you do want to have the clients order it before you get into escrow. On your contract, it says that the seller is to provide to the buyer any reports within 7 days. That's on RPA number 14A. That has to do with time and contingency, removal of contingencies. All reports need to be submitted by then for the buyer to review, and if not, then the buyer can cancel, right? So if, with that in mind, the LA City report, when you submit the application, if you do it online, it could be 7 to 10 days. If you mail it in with a check, it could take about 3 weeks, even 4 weeks if they get busy. Yeah. So you really, really, really don't want to wait until you get into escrow. Plus, once you get that report back, it's going to let you know whether there's a sewer line connection or if you need to do a dye test. It's going to let you know if there's any weed abatements, any fire, any brush, anything like that. A lot of times it's clear, and that's great. You know, you've gone out there, you've done it, you made the property look good, and that's all great. But sometimes you get these random ones or these lots, and the brush is all a mess, and buyer said, I'll take care of it. But when you get that report back, what if you have a 10-day escrow, or a 15-day, or even a 21-day, and you've waited a week or two into the escrow process to order that, and it comes back, and then there's all this stuff that needs to be done. So we had the LA Fire Department come speak to the escrow association. They brought this little flyer with them, and they let us know also that if you get something back on the 9A that says it's not clear, it doesn't really tell you what it is. You have to do a lot of investigation to find out what it is. The first time, there's certain times during the year, like this time of the year right now, brush has to be cleared out by April 30th. If not, then you get a fine of $28, a notice and a fine saying you need to take care of this before the end of May. And then during May to June, the inspectors come out and they do their inspection to make sure everything's done. If you're in non-compliance, now you get a penalty of $432. And then you got to do some work. Some time goes by, you forget or whatnot. What if escrow closes during that time? You don't know. You know, what happens is they start getting bids from contractors to do the work, and then it takes the contractors a while to do it, and then the invoice goes out, now it's November. What if your escrow closed in the 3 weeks when the first notice went out? Buyer had no idea about it. And now the buyer, what happens is when those penalties don't get paid and the invoice goes out, it gets tied up into your tax roll. So your buyers now are stuck with this huge bill that they had no idea about. They never got any notices because it went to the seller. So they do have a website you can go to if anytime after May 1st, you can log into, if you want to write it down, it's vms3.lafd.org. You put in the APN number and it'll come up, the status will come up. If it's NA, it hasn't been inspected yet, but if not, it'll tell you whether it passed or not.
Can you repeat the website?
Yeah. Yes, it's V as in Victor, M as in Mary, S as in Sam, 3.LAFD for LA Fire Department.org. But this is a really critical time right now. The brush needs to be cleared out, everything done by April 30th before the inspectors go out, because between May and July, it's kind of like a up in the air thing. Just make sure. Try to get it done before you open escrow so that you have time to tackle these issues and you don't delay the closing or you don't get stuck with a huge bill that you didn't really know about.
Thank you, Vanessa. So I have one more question for each of our panelists before we open it up to the floor for questions. So Jacqueline, if I help my buyer get $5,000 credit for closing costs, but the buyer's closing cost is only $3,000, where will the difference of $2,000 go? Will it go back to the seller, or will you give it to my buyer as an extra check after closing?
Well, I think first we should see if there's a loan involved. If the buyer is getting a loan and it's for owner-occupied, most likely the lender will have requirements on what they can get the credit for and how much they can get the credit for. Usually the lenders will allow for non-recurring closing cost credits. That's usually not a problem. And non-recurring closing costs are things like title fees, escrow fees, recording fees, appraisals, underwriting fee for the lender. And most of the time, these non-recurring closing costs, depending on the size of the transaction, it's only about a few $1,000s. But in addition to these fees that the buyer need to pay, they also need to pay for things like tax prorations, prepaid interest for the lender, insurance premium, and maybe HOA dues. Now, if the lender would allow credits for both non-recurring closing costs and recurring closing costs, then the buyer would be able to use more of the credit. But even sometimes after we apply all this, it's still not enough to absorb the whole entire credit. We could have maybe the buyer can consider asking the lender to set up for an impound account, or if they're just paying 1/2 of the property taxes, they could possibly prepay the second half taxes as well. And if they have HOA dues to pay, maybe they can ask the lender if they can pay their entire year of HOA dues ahead of time and get a credit for that. If there is no loan, then maybe the parties can consider amending the credits. I have parties who would credit for like future repairs or upgrades to the property. And so the bottom line is we must apply the credit the way it is specified and allowed by the lender. If there is any unused portions, we may not, and we cannot issue an extra check for the buyer after the close of escrow. Okay.
Thank you, Jacqueline. Lena, what is the 593-C form? How do I complete it?
Okay, the 593 form is, as you know, every state have their own requirements. And in California, we are required to withhold income tax based on a value of 3.33% of the purchase price. Now, this is a form that we provide to you with the escrow opening package. You will really, it's one of the forms that the seller needs to fill out. Now, if the seller is married or has a domestic partner, they can, a couple can fill out one form for themselves. But if you have more than one seller, then each seller must fill out for each person. They each must fill out their individual, their own 593 form. Now, there are some entities that are still considered individuals, such as a single member LLC. If the LLC has a single member, they are considered individuals. So therefore, they will have to fill out the tax ID number, and if you are not exempt, you will be subject to withholding. If you are a grantor's trust, like a family trust, and the family trust, you are basically sometimes using your own personal social security number, then that is still considered an individual. So that will be subject to withholding as well. Now, there are certain exemptions that automatically exempt from withholding, and that is if the property is 100,000 or below. So of course, you know, in this area, we don't see that happening very often. So, or if the property is being foreclosed upon, or a deed in lieu of foreclosure, those are exempt. And if a bank is acting as a trustee, that is also an automatic exemption. And the rest is if you fill out the form, you need to consider, now if the seller is, the property is the principal residence, and by principal residence, it means 2 out of the last 5 years. So if the seller lived there 2 out of the last 5 years, then they are automatically exempt. And there are other forms, of course, if you are an LLC, a corporation, or if you're selling at a loss. Now, if you're selling at a loss, you are exempt, but you are subject to filling out another form, which is the 593E form. And the other exemptions will be if the seller, if it's an investment property, if they are doing a 1031 exchange. So So if they're doing a 1031 exchange, they are also exempt. So as long as they mark an X, that any one of these exemptions on that form, they will qualify for the exemption. Thank you.
Thank you, Alina. And Vanessa, how should the buyer or seller sign the purchase agreement when they are in a trust or signing on behalf of a corporation or other entity?
So this question comes up quite a bit. On the purchase contract, on, let's say, the residential purchase agreement, pages 9 and 10 is where the buyer or seller signs, right? So if you're an entity, say West San Gabriel Association of Realtors, as a seller on page 10, you have the name there. But up above, they would sign, so it would be Albert Tran, he would sign. So, and then you mark the box, there's a little box above the signature that has, if you are signing on behalf of an entity, you check that box. And then it attaches an addendum called the RCSDS if you're a seller, or RCSDB if you're the buyer. That stands for Representative Capacity Signature Disclosure, I believe. Yeah. And that form will come along, and then on it you would put that the entity or the trust is the seller or the buyer. And then down below you put who is signing on behalf of that entity and their capacity, whether they're the manager or the trustee or president or so forth. And there's certain items on there that are also a reminder that you need to get certain documents to show that they do have that authorization within, I believe it's 3 days of acceptance. So please use that. There is a way, if you're signing it through like zip forms, they have a tutorial that'll show you exactly how to do it. Because it's really, I know it's really confusing because you put in the entity and then they're signing WSGBR, and that's not correct. They should be signing the person's name. So there's a instructional tutorial video on zip forms by the Zip guys. I have it on my, I don't know if I can plug that in, I have it on my Facebook, Vanessa James, escrow officer. I put it on there this morning so you guys can go back and take a look and see how they do it. But you're basically creating another signature envelope, I guess they call it, to put those, and you drag in the name so you can change out who the signer is. But your client is the entity, but the signature is the one you need to have the individual. The initials should be the individual's initials.
Thank you so much, Vanessa. Well, that's a lot of great information, and thank you for sharing all these resources with us. I'll go ahead, I'm gonna open up to the floor, see if they have any other questions. If you don't mind, we have about 5 to 10 minutes to answer additional questions, okay?
I'm wondering what your opinion is on the online notary that looks like it's coming down.
So that's a really great question, Lorraine. It's not yet approved, it's still, bill has to pass. Like, we don't know, we were talking about that. We've been talking a lot about it in the Escrow Association and Escrow Institute, I'm sure. And there's lots of webinars. The issue with that is that the county, the issue with that is that the county recorders for California do not allow it. They don't allow, we actually had a transaction where we tried to see if we can do it. The client went down to Mexico and they got sick. So they didn't make it back in time. They got really, really sick. And the only day they can sign was on a Friday. And they don't sign at the embassy on Fridays. I don't know, Juliana. Well, hi, Juliana. So they had to really, really think. They called, they wrote a letter, they did all this thing. They actually got a notary to meet them. But they were we used an online notary company. What they can do is they have the webcam, they have it all set up. The notary signs in, I think it was like Virginia or something like that. And we were going to have them send their original signature back, and the notary was going to send the original notary acknowledgement. But they are notarizing. It's not allowed. They can't record. The county cannot record the electronic signature, and the notary company that does online for another state will not allow the original acknowledgement. The acknowledgement is electronic. It's an acknowledgement of the electronic signature. So you can't piece them together. The notary company won't allow that. In other states, they do allow electronic signatures for recording, but not in California. So it's gonna be a little while. I don't know if you wanna comment.
Yeah, the Escrow Institute of California is very concerned about this bill as well. Particularly, we're concerned about the storage too, of personal data. Because they're talking about storing it in the cloud, stuff like that, and we're like, well, whose cloud? Who's able to, who's storing it? And how are they taking care of this private information, confidential information of the signers? So we are very, very concerned about it.
And then also who the notaries are gonna be that are gonna be allowed to do it.
Yeah.
So,
And with webcam, you can only see a certain angle, so you don't know if there's, anyone, I don't know, yeah.
I think California Escrow Association are for it with some exceptions, and I think Escrow Institute is against it with some exceptions. But we're basically the same place because the bill's not quite right yet.
But the county doesn't accept it.
But the county doesn't accept it anyways.
Yeah, right now our position is opposed unless amended. And we just heard, I think, earlier this week or late last week that it has turned into a 2-year bill now instead.
Right.
Okay, now, what do you do if the seller doesn't want to sign and they are foreigner for the 15% report?
Well, I don't think it's an option. They have to fill out a form whether they are a foreign person or not, that's number one. And if they are signing that they are a foreign person, then you have to apply. There are some companies that you can go to and apply for Social Security. They give you a temporary Social Security number, and then, but the percentage is applicable unless you're selling at a loss. But you have to apply early on to ask for an exemption for that.
Yeah, but what do the escrow do, or the buyer can do? Who is responsibility for the 15% if the seller don't want to sign? That's what happened. What is happening to me?
The law says that it is buyer's responsibility to do the withholding. Believe it or not, and it is the buyer, not escrow, not the seller. So it is very important that the buyers know that it is their responsibility to know whether the seller is a foreigner or not. If the seller is a foreigner, if they don't sign the FERTA, what we call, which is a certification that they are a non-foreigner, then automatically is subject to withholding. And we just need to deduct that, and we do. And you need to check with your escrow company because not all the escrow companies will do this for the clients. Most of the escrow companies would help the clients do the remittance to the IRS for this withholding and to the franchise tax board. But there are some that won't, and they do specify that in their escrow instructions. So it is important that you do read it or ask the escrow company whether they will do that or not for the buyer. Do we answer your question?
It's buyer's responsibility.
The buyer, so.
That's what the law says.
So what the buyer can do, what can the buyer do for this situation? The closing escrow is going to be in 3 days or something. I mean, it's not the I know before was escrow holding, but now it's the buyer's responsibility to hold it. How can the buyer do it? I mean, what power do the buyer have?
Well, the buyer just needs to know that it's done on their behalf.
But if not done,
Well, you can ask the escrow company to provide you with a copy of the check that was sent for the withholding and also the remittance paper. Actually, the buyer needs to sign a form for us, and it's the Form 8288. And that form is signed by the buyer, and the buyer needs to provide their social security number on there. And we use that and send it in with the check that we cut for this purpose. So that will be proof to the buyer that that has been done.
And feel free to reach out to any of our panelists anytime before, after our meetings, because they're here to help out. We do have one more, time for one more question.
How does escrow assure themselves that trust documents submitted to them are not fraudulent?
I don't believe it's for us to determine.
Well, how do you protect the buyer and seller?
The trust documents are provided to the title company for review, and then the seller, the title company uses that information to cross-reference to match the signature of the prior documents to match, and that's what they do with any regular transaction as well. The title company reviews it and matches the signatures against prior documents submitted. And if there's no prior document submitted, they will sometimes ask you for an ID. The seller will have to provide a copy of their ID. And sometimes we've seen title companies request for that information to prove the validity of the owner.
For every transaction that's in a trust, we require, and the title requires a certification of trust, which is signed under penalty of perjury, and that releases us of that responsibility.
Yeah, and actually, the trust agreement should be notarized as well, and the certification of trust has to be notarized.
Right.
Yeah, so we do depend on the notary to present this as an authentic document.
And I would encourage all the realtors, when they get a client that's in a trust, to get also a copy for themselves, so they know who the authorized signatories are. Especially, I know we talked about this earlier, but we don't necessarily need all the pages, but definitely if there's a party that has passed away, we're gonna need to see what happens to that trust afterwards and who has the authority after the person has passed.
Thank you again. Vanessa James, Viva Escrow, Jacqueline Chow with Champion Escrow, Alina Chu with Glen Oak Escrow. Thank you, everyone.